Good afternoon, everyone. Thank you so much for coming out. My name is James. I'm hosting this panel on behalf of the Mining Law Club here at the law school. Big thank you also to the Center for Business Law and the Indigenous Law Students Association for co-hosting. I would like to begin by recognizing that the UBC campus is located on the traditional and ancestral territory of the Musqueam people, and also to acknowledge that the land remains unceded. Today, we are honored to be joined by three incredible panelists. Robin Sidsworth, Director of Government and Indigenous Affairs at Teck Resources. Thomas Isaac, Partner of the Business Law Group and Chair of the Aboriginal Law Group at Castles Brock and Blackwell. And Merle Alexander, King's Counsel and Principal Lawyer at Miller Titterley and Company. Before I very briefly introduce their practices, I would just like to give a sincere thanks to Robin, Tom, and Merle with respect to taking the time to be with us here today. And also apologies for just sending them so many emails over the past week. Just as an introduction, Robin started as corporate counsel for Teck in 2011, serving as primary legal counsel on negotiations with Indigenous peoples at Teck's Canadian operations, and advising on community, regulatory, and sustainability matters within Canada and abroad. And Teck is a Canadian mining company focusing, would you say, increasingly on copper?
Yes. Yeah.
Yeah. Okay.
Yep.
Yeah. And Tom has extensive Thomas Isaac. Tom has extensive national experience advising energy, oil, gas, pipeline, mining, and forestry companies, lenders and investors, and federal, provincial, territorial, and municipal governments and agencies on Aboriginal and project-related regulatory and environmental matters. He regularly negotiates on behalf of industry and governments concerning impact, benefit, economic development, replacement tenures, and access agreements, as well as consultation and accommodation processes and agreements. Merle is a life of project lawyer, Merle Alexander, joining us on Zoom. From Victoria, I think. Merle is a life of project lawyer, assisting with negotiations of all stages of impact benefit agreements, joint ventures, regulatory engagement, traditional knowledge collection, and other corporate and tax-related advice. He supports clients in emerging government-to-government negotiations in all resource areas, including mining, oil and gas, forestry, pipelines, run-of-river, and hydro projects. Also, a major component of Merle's practice currently involves the ongoing legislative implementation of the United Nations Declaration of the Rights of Indigenous Peoples, UNDRIP, in BC and Canada. So great, thanks to all of you for joining us sincerely. And that, of course, was a very brief introduction of these super impressive practices, just because I thought it would be great to hear from the panelists themselves how they would describe their practices. I think that would be great just for us in the room, and yeah, so just hear more so from them. And with that, let's launch in. So just as an introductory question, can you describe your career path and what led you to your practice today? I'm wondering what led you to the Aboriginal and Indigenous law field. And Tom, maybe we could start with you.
Sure, thanks, Robin. Thank you. Real pleasure to be here. It was good to be at UBC. So for me, I was in my second year. I was 19 years old, and there was a course called Native Peoples in the Law in 1985. The charter came into effect 3 years after Section 35 of the new Constitution. And I went to that class. I remember very clearly there were 3 people in the class. The professor teaching the class ended up being, I think, the first Indigenous Lieutenant Governor in the country, Grady Nicholas, holistically. member. And there were two people from this community, Toby and me. And I was just really interested in studying political science at the time, and instantly fell in love with the area. There was no books to read or anything at that point. There was very old textbooks, and really, there was really an empty piece of paper as to what the Constitution Section 35 meant. So ended up doing a master's in political science and focused on law. And then started my career out in public service, government of Saskatchewan, went to the Northwest Territories, was responsible for setting Nunavut, and then was chief treaty negotiator in BC, and then decided to practice law. Again, I think everybody will maybe laugh at me, thinking maybe Merle Robb will get a kick out of this, but I remember I started my career at McCarthy Tetro, and sort of people were like a little dubious, like Aboriginal law, how does that affect business? It surely won't affect Canada. And I said, no, trust me, this is going somewhere. And really within a few short years, sort of what we, I think now think of as sort of modern Aboriginal law really took hold. It's really only been the past 20, 25 years in terms of fully understanding. So, and I've just spent my career past almost 25 years practicing across Canada, including acting for Indigenous governments. Over the past few years, we've taken on mandates. We're really proud to take on some mandates for Indigenous governments. So, and then do everything from litigation to a lot of litigation work. I think I've appeared for almost every court in the country. A lot of negotiation work, a large team. Yeah, that's it.
Yeah. Maybe Merle, we could hear your career path.
Hope you guys can hear me well. Can you?
Yep.
Good. Okay. Excellent. Yeah. Well, and I would say, I had that very similar boring undergrad, also political science, which I thought, oh, this, especially all the like Canadian government part of it, which was particularly boring, and the international part of it, which I thought would be completely irrelevant when I was like doing my but I did a political science degree thinking that it was just the passport to law. I mean, I always wanted to work for First Nations or for Indigenous peoples, but I didn't really like have a sense. It was all grandeur, like the idea of arguing the big case before the Supreme Court of Canada and changing the landscape. It was sort of like this grand, that was the grand idea. And then came law school, which isn't as grand as you guys are experiencing, probably. But I went to UVic Law, and I was really fortunate to get into the UVic Law Co-op program, which one of the co-op placements that I had me at a really small little firm called Woodward and Company that was only about 3 lawyers at the time. And it just so happened they were working on this case that was going to the Supreme Court of Canada, Delgamuukw. So I'll instantly date myself, which maybe only Tom understands. That's like the summer of or the spring of summer of '96, I was working on intervenor factions for Delgamuukw. Got to go watch it get argued, and then of course, the spring of '97, and then I got to watch it argue for the Supreme Court of Canada, and then I started looking for my next co-op job, which took me to, which had me looking for jobs in Ontario. And I think I was on December 11th on the afternoon, the day that Delgamuukw came down, all of a sudden somebody hired me at the last minute. I was already packed and ready to go to Toronto, but to go meet up with my girlfriend who had quit law school and decided to go to Ontario. And that sort of became actually a strangely sort of illustrious career. And it also is what changed my career path, because I sort of got to see like Delgamuukw implemented and see nations take a case to the highest court and not really have it dramatically change things, even though the case is sort of like a preeminent case. So on a whim, I just decided like, well, I guess this litigation thing is not going to work so well. Maybe I should be a solicitor, not knowing what that meant and only having a poli-sci degree. And so I just sort of decided that I would be a solicitor, and I moved back to British Columbia, worked then at Davis and Company, now DLA Piper, told them my story. I only had one interview and they hired me. And then it just so happened, at the time there were no there's very few First Nations like law practitioners, particularly in large firms, which at that time seemed like the evil empire. And got hired, did some amazing work at DLA Piper, and that just sort of as surprising as it was to me, that actually became a burgeoning practice, and that was in 2001, and now 23 years later, as we know, the build out of the Indigenous sort of resource law business development practice is really significant. In fact, the firm that I work at, North Tiddley, probably has about 25 solicitors that are just working specifically on the area. At a time, like in 20 years, it went from being like an obscurity to part of every single major national and international law firm in the country. So it's all of that on the whim, and also that on the disappointment of thinking that my grand career as a litigator wasn't going to be as grand as I hoped it to be, but it turned out okay.
Thanks, Merle. Rowan.
So I'm much less illustrious than both Tom and Merle. Tom is actually what got me into Aboriginal law. So I'm like part two, but less impressive. So it's like most part twos of most trilogies that you're familiar with, right? They're worse. The story continues. So I summered at McCarthy in 2006. And I think I was just seated close to Tom. And I'm not sure how many of you have had the experience of summaring or articling in some articles like that, but whatever people want you to do is what you're definitely going to do. But I would say, there's a group of students. Tom needed help, I think, on a few different matters, and I think I just kind of gravitated towards the work that Tom was doing. I have like maybe an interest in natural resource development. Generally, I grew up in Prince George. I'm not sure how many of you folks are familiar with the lovely city of Prince George, but my family has like a long history of working in forestry and mining. The miners are all geologists or like those things like that. So I like the idea of natural resource as an area of work. I find it interesting. I think maybe being from a town where forestry and resource development is a big part of the makeup of the town, I felt some affinity for it. And then I think in very short order, I found myself really interested in just the area of practice. So I found working alongside Tom. Tom's a really thoughtful guy with lots of interesting observations on both business and I think development of the law. And I think what attracted me though is that and I thought Merle, your observations about seeing sort of these big seminal cases translate into then changes in politics or changes in practice or changes in business has been interesting, because for me, I started my practice kind of after a lot of the really big sort of foundational cases, and certainly they've been built upon since then. But I started right after consultation law became like sort of a really prominent part of a lot of practice around Aboriginal law. And so I often describe working in Aboriginal law as like applied philosophy, because you get into these really interesting discussions of use, which is what I do, where you take a lot of these interesting legal principles. You work with Indigenous groups who have very different political and governance and legal structures, and then you're often trying to craft some way forward together. And I have found that really interesting and really engaging, because depending on what you enjoy doing, but if you like negotiation work, which I do, and you like trying to figure out ways that you can work with people, it's a really interesting way to do it, because there's not often that you spend your days sitting there talking with people who have completely different worldviews than you, and who will explain to you why your way of thinking about things is totally wrong. And you just get to sit there and listen to people, explain a very different way of being, and I find that really engaging. So Tom got me started and unleashed me upon the world. Merle hasn't had to deal with me too often. Hopefully I'm okay to deal with most times, but
Yeah, well, thank you. It's always very inspiring as like law students to hear, about the career paths of prominent lawyers and, so thank you a lot for that. And just on to the next question now, a bit more substantive related to practice. And introducing your own respective practices. So what do clients need when they call you? And Robin, the question for you would be, what guides your role at tech? So we can start with you, Robin.
Sure. So I've had a couple different roles at Tech, whether it's whether you're corporate counsel or I'm now currently functioning in a sort of semi-legal capacity. It is often problems. It's what draws you to external legal counsel. You encounter a problem, realize it's got a legal component, and you typically realize you're missing the expertise you require to figure your way through it. And so I know in the mining sector, there's increasingly, I think, an awareness that an understanding of Aboriginal law is actually kind of a fundamental core need to your business. So early on in your project planning and other things, you'll seek out the expertise you need, and you will look for advisors who have the experiences that you are actually experiencing yourself. So if you're trying to negotiate, you hire a negotiator. If you're in the middle of litigation, you hire a litigator. But often what you're really interested in is somebody who's going to help you solve the problems that you've got as business. So if you can understand your problems, then you can go and hire counsel. But sometimes you need smart folks like Merle and Tom to actually help you understand what your problem is. Because sometimes you just know you're not getting anywhere, but you're not quite sure why.
Yeah, thanks for that, Robin. And yeah, for me as external counsel is having a client explain what the problem is. I think that was a good lead up to that. And not only understanding what their problem is, what it is they're trying to achieve, and what their risk tolerance is. The risk tolerance, at least for me, is particularly important because we'll deal with some clients where they're fundamentally concerned with their public reputation, and this is whether it's a publicly traded mining company, Indigenous government, public government. What is the risk tolerance and what's important to that client? I've dealt with clients that, as a matter of principle, something will be critically important to them. I'll deal with clients that have an immediate concern. By immediate concern, within months they need something done. Whereas you'll deal with other clients that are thinking in decades, or I do a lot of work in the nuclear sector. They chunk the world out into 50-year chunks. This is a very, very different perception of what risk is and the tolerance. So I think understanding problem, and again, for me, getting the problem, but really understanding the risk tolerance is what they are doing to manage risk, because that then will kick out what the options are. Because theoretically, you can do anything almost, but whether it's practically the right advice is completely different from what is possible. The probable is really where you try to get yourself focused. Over to you, Merle.
Yeah, that's an interesting question because it's sort of like what does the client see you as your brand in a way? Like, what are you like? What's the problem you best to solve? I think like these days, partially because I'm also really trying to sort of like I'm doing so much like work in that area, is trying to clients always have always come to mostly when there's a resource company of some sort, whatever scale, knocking on their door, and they need assistance with negotiation. So that's like sort of like normal criteria one. But then I think like nowadays, especially with the sort of the files that I cherry pick, I think that it's mostly trying to think through what does consent mean in terms of the resource agreements for negotiating, because I think there has been a shift in the law away from accepting just consultation based impact benefit agreements to more of a free prior informed consent framework. And I think that shift is happening like on both like the proponent and the First Nation side, because at the end of the to achieve a consent-based like resource agreement also like has a much higher degree of, has a lower risk, it has greater legal certainty, and hopefully greater certainty for the project, greater certainty that there'll be a legacy, in the community, and that the next political change, the change in political leadership, will still stand behind the agreement. So I think nowadays it's that sort of like looking for someone who's going to help them think through what does consent-based agreements actually mean. Because I think everyone will ask for it, but the next question is like, what does that mean? What does that mean to you? And I think that's where the hard work is. There's also like where it's extraordinarily intellectually interesting to sort of think through and really see First Nations and other Indigenous peoples think through what does consent mean pursuant to their own First Nations legal orders. Because I think that's like where the law is also trending. There's the consent part, which like affects our resource practices, but that shift to like looking at actually the jurisdiction of nations and their legal orders, I think is also one of the major shifts, which of course you see of course in the course offerings and UVic's GID program. I think that's the shift that we're going to probably see change our careers, because it's sort of like, I mean, I'm more or less like mid career, so I think that that's just going to be the most influential force, will be like the application of Indigenous legal orders, because we all practice the common law of like, Aboriginal law as interpreted by the common law. But the shift that's happening is like, well, what about the Indigenous jurisdiction? And what about self-determination? And those things are very front and center with UNDRIP implementation in British Columbia. It might not be the case like all over the country. And the federal implementation will probably be very slow. But in British Columbia, I think that shift is very real. And the more you start thinking through and adapt it to that, I think those will be the proponents and the nations that will do best by it.
Yeah. Okay. Thanks, guys. So on a similar note, what does a typical day in your life look like? You might outline, various typical days depending on like specific projects you've worked on. And generally, I'm just trying to get a picture of like what's on your mind when you're on your way to work in the morning, for example. And Merle, could we start with you?
Sure, I'll just randomly choose a day in the week. Like right now, I'm doing something really interesting where we're like, of course, I think as was sort of said in the intro, like I'm really involved in the implementation of UNDRIP, which means that like that's part of the legal reform of almost every BC statute, one at a time. Right now, the most interesting and active one is the Mineral Tenure Act, which just happens to be very interesting to probably my fellow panelists. So right now that's consuming a lot of my time. So I'll probably spend some on any given day these days, I probably spend like 2 or 3 hours like on Zooms or either prep meetings for internal meetings with the First Nations Leadership Council, which I represent I represent the BC AFN. And then we're just trying to like really take a look at the Mineral Tenure Act and try and determine what does consistent with UNDRIP mean, which is no small task. So that's is filling about at least a third of my time these days. The other part that I'm doing, which is actually very much is an excellent like counterpart to it, is I'm really involved in a negotiation between a First Nation group and the province on creating a government-to-government agreement, which will also implement UNDRIP. You can see a theme here. So we're also trying to think through what does a co-jurisdiction environment look for the province. And strangely, we're actually anticipating what's going to be amended in the legal reform hand with what we're negotiating on the government-to-government hand simultaneously. So it's a really exciting and interesting and intellectually challenging time. But that actually is like I could look at my calendar this week and see that's like those are the two core themes right now. So I mean, it is a very interesting time to be practicing in this area.
Yeah, very interesting question. For me, I guess as I move through my career, I'm at a point now where I've got sort of a bifurcated job. So most days I feel like I'm a manager, not a lawyer. So that's been interesting to get used to that over the past 5 or 6 years. It's been a real big change. So we have hundreds of matters that are open, every territory, every province of Canada. And on any given day, I might look at 10 or 15 files. So it's very exciting, it's very stimulating. You can get addicted to the stimulation. I do, I really enjoy it. But it's totally different from actually being a lawyer as far as I'm concerned. I mean, it's law, but it's a very different, you're trying to sort of apply sort of macro experience, I guess, to particular files. And then there's another side of the practice. So I think there's about 13 full-time lawyers who work with our group now. And we probably have another 20 that regularly service the group, primarily real property litigation. The other side of what I do is act as a lawyer. I'm acting as a lawyer when I'm a manager too, but it's really sort of it's not getting into the details, which is sort of frustrating. So most of my sort of day-to-day legal work is primarily litigation, usually litigation strategy, or as like this year, so I don't know exactly the dates, but I'm 2 weeks out east for an Aboriginal title hearing. Supreme Court of Canada in the fall, actually defending First Nations and Métis rights to be consulted by the very challenging government of Saskatchewan. A couple regulatory hearings with the Ontario Energy Board. I don't do as much of it, but as I used to, but I usually try to do a few hearings every year. So it's really, it's great though, and I really enjoy what I do. I guess I'm reaching that age. Somebody actually asked me about retiring. Just the idea of retiring isn't. I really love what I do. So I don't think that's in the cards, at least until they push me out, which is always a possibility. Enjoy.
Yeah.
Sorry.
Nobody pushes Tom around. Yeah, so in-house work is interesting because you spend less of your time doing, I would say, really a more formal legal work, where you're, say, really deeply investigating a legal problem, writing a memo. You spend a lot of your time working in multidisciplinary teams. So I spend a lot of my time on teams. I hope you enjoy meetings. If you don't, you may have chosen the wrong profession. Well, you do litigation, then those are sort of very formal meetings where you just yell at one another. But you spend a lot of time in rooms, and you spend a lot of time with people who bring to the room different experiences, different professional backgrounds, and you're typically trying to figure out what problem are you all there to solve, which is not always apparent when you start meetings. And actually, a big part of the job is figuring out how to bring your particular area of expertise to bear in a way that is productive and that will help other people understand what you understand. And so that you can make better decisions together. And so in-house, the nice feature of that is that you tend to spend a little less time doing the deep legal thinking, and you tend to do more applied decision-making with bringing together sort of legal advice. And in my experience, the best lawyers working in business, I've had the pleasure of working with lots of great lawyers with all sort of different backgrounds. It actually doesn't, their subject matter expertise is not as important as their ability to work as part of a team and to actually think about legal risks as one set of business risks that need to be managed. And whether they're business risks or I think any other organization, your legal advice is one piece of advice amongst a bunch of considerations. Sometimes it's paramount and absolute. You can't break the law. If that's the thing you're debating, the legal advice is going to carry the day, hopefully. But most of the time you're choosing between options, and you're choosing between situations where there are different legal risks and there are different options, and you're trying to weigh benefits and drawbacks. And so people who get very skilled at not just thinking about what is the law, but what does it mean? What are your tools to manage, right? What are your options? And if you're going to choose an option that's not very attractive from a legal perspective, how to make sure people actually understand what that means practically. So it's funny, I spend a lot of time actually doing very basic legal stuff with people who forget like what litigation is going to look like, how expensive it is going to be, how much time it is going to take, how likely it is there to succeed. I'm not sure if Tom and Merle find this, but I find most of the time, if you're in a room, people are really thinking about suing somebody. They are typically early on very excited about winning and very convinced that there is an injustice against them, which they are going to solve. And it can take real guts to sit there and go, that is not right. And get ready for this, you might lose. And you might actually be the bad guy here. People don't like to hear that. So a lot of those skills are sort of soft skills, right? They don't, they're not the things that you necessarily learn from the law, but you do learn from, well, you certainly don't learn from listening to me talk, but you learn through your career and other things about how to just work with people, right? And so that they actually really hear your advice and they can work with it.
Yeah. Okay, great. So just moving right along. What is the most important aspect of the initiation of private industry and Indigenous community relations concerning proposed development projects? Of course, assuming there's a valuable economic opportunity to be developed. What's important if something like that is located of first getting in touch with Indigenous communities with respect to that project? Robin, let's start with you. Or you know what, does this translate to
Are you thinking lots of our minds have been where they are for a long time, and so we're a little late to the consent party, because that would be true.
Oh, right, okay, well,
Yeah, so I'm happy to start, and Merle might have a better, and Tom, if you work more with Indigenous government. But yeah, I'm happy to start. So for people who don't know tech, it's a fairly long-lived company in the mining context, like about 100 years. So a lot of the mines we currently run have been operating for 40 plus years. So it's a long time. And it means that when you think about all the case law that's just been described, right, it predates a lot of that social development. So most of our mine sites, the exploration, the early development, all happened without any consultation, without any consent, without any effort to engage Indigenous people at all, right? So that's the SAR, and frankly, that's the SAR history of mining largely, up until the last 20 years where that has started to change. So that it creates a very specific context in which you're then trying to negotiate forwards when you've got this difficult history to contend with. So it is interesting so the question is like, what's where do you have to start? I think the most important thing in my experience is actually starting with an understanding of the context that you're in, which means you have to acknowledge the history of the region, you have to learn it. And typically the most important thing is to actually start talking to the Indigenous community and the government at the earliest possible moment, before you've come up with all of your bright ideas, before you know exactly what you want to do. And the first thing that at least I always counsel is that our earliest engagement should be actually not about explaining ourselves, but on understanding. I shouldn't use us and them. Probably that sort of feels oddly absurd. But I think you think of yourself as a guest. You're a tenant, and that's always the case. Whether it's an Indigenous government or otherwise, right? You're always, you're on somebody else's land, and so your starting point needs to be. You have to understand where the community's at, what are their interests. If you've got an idea, you have to figure out whether your idea is compatible with what they want to do. Because if you want to build a mine in an area where nobody wants a mine, that's going to be very difficult. And what you should be doing if you're thinking about it from a business perspective is assessing early on, if you want to be more singularly business-minded about it, is this a good place to spend your money? And if people don't want your project, then you really shouldn't spend a lot of time and capital trying to convince people of something when in fact they might be telling you right from the start, no, thank you, right? Take your good idea somewhere else. So maybe Tom and Merle, you could, that'd be interesting in your views, but that's my experience. You have to start talking early. And ideally you start talking to people about what are they interested in before you start talking about what you want to do.
Maybe I'll just jump in and pass over to Merle. Look, I agree, Rob, with what you said. One thing I say to our industry clients in particular, I'll come in, we'll meet people, and then immediately we'll have ideas of what First Nation X or Y or Métis or Inuit group A and B want and what's important to them. And so I actually give them the same advice Robin just said. Really, it's almost irrelevant what they think somebody wants. That's probably overstating it a little bit, but it's probably pretty close to accurate. And what's more important is early engagement, respect, and regardless of which client I'm acting for, whether it's a public government, Indigenous government, industry, expect respect from all sides of the table, and that's critical, absolutely essential, and due diligence, and part of that is listening and trying to understand, and then you're in a better position to try to figure out exactly what your next move will be. I do agree with Robin as well about and I would say it's less often than not, but occasionally, like if I'm on a mining project in particular, some of those pipelines, you'll come across an Indigenous government that has a very strong view that is not favorable to your project. And, this is something that I've seen sort of A to Z on this from corporate clients. Some that will stick their head in the sand, hopefully the issue goes away, all the way to we're going to rethink equity ownership of the project and open the doors up, and mostly everything's somewhere in between. But it's really, again, respect, coming to it with your eyes wide open and sort of an open mind. And that may sound quite soft in terms of an approach, but it's really smart, I think, from a strategic and risk management perspective. Again, whether you're an Indigenous government, public government, or let the other side talk first, and try to understand where they're coming from, because there's no use. Whatever you do, whatever you put on the table, I put it this way: is you want, if you're putting something on the table, whether you're an Indigenous government putting it on the table, with your industry, a business putting it on the table, what's your worst scenario? Your worst scenario is somebody not giving you full value for what you're putting on the table, whether it's giving you permission beyond their land, whether it's offering you an equity ownership stake in their business, whatever it may be. And so it just strikes me prudence, risk assessment is absolutely critical, so that what you are putting on the table is relevant and is hopefully getting as much value as what you intend to get out of it. And these things don't go without saying. I've been doing it too long, but I've seen so many clients, again, from all the different camps, come rushing into something and really not sort of think through what they're dealing with on the other side. We've got a public government right now that we're dealing with. You might guess which one based on my earlier discussion, but on its face, looks like it doesn't really care too much for its Indigenous population, unfortunately, in this country. And it's an extremely challenging government to work with. And you're trying to figure out options that will actually move the bar. And we're coming down to there's not many options left. It's a tough discussion to have, because you're bringing all the GR for everybody's got ideas, and we've tried them all and they don't work. And so really challenging stuff. But again, you have to keep your eyes wide open and try to figure out the strategy forward. Merle, over to you.
Yeah, no, I think we all agree. I think that having any presumptions about the community, or I guess even or the proponent ahead of time is not mostly helpful. I mean, you should do due diligence to try and get a basic sense of who you're going to meet with, but then you also have to not be presumptuous about what's really their drivers, and try and create, I think, a framework for open and long dialogue. like I think that like one of the most challenging aspects, especially probably for proponents, is the patience that it takes to develop like the relationship. Because I think like for, I mean, any given First Nation is going to have like dozens of proponents like come through their council chambers, and those that come through the doors and are like put off being like a degree of arrogance or an entitlement because they already have certificates granted to them, or an idea already what the deal looks like, that what the nation wants, that almost always like leads to a degree of like either, well, it just makes the conversation longer because you have to work your way through those things, those false presumptions. But I think it's sort of it seems like a very like I mean, you're in a way you're sort of negotiating a relationship from the moment you come in the door. So like being open-minded and really like presenting that degree of humility that you do not know that you're there to sort of learn from each other, I think is actually probably the most important thing, which probably sounds like very like more like psychology 101 versus like like the wise words of old practitioners. But I mean, I just think I think that's the most important part of it, is that like it's a real human engagement. Like you have to be adaptive and learn to sort of read each other and listen to each other about what you really want. I think also more often than not, and that's the success I think of these practices, is there's more to agree on than there is to disagree on. And of course, there's going to be a certain project where somebody wants to turn like a lake into a tailing pond, where that's just not going to go very well from the start, and you come roaring in and that's your plan. Then that's not going to go so well. We've seen a couple of those stories go badly. You might have heard them. But I mean, I think that if you're, I think more often it is like the desires and the needs of a First Nation are those that you have of your own family. People want to see their children do well. They want to see them have skills. They want to see their socioeconomic status grow over time. They want to be respected. They don't want their environment destroyed. Like, I think these are all these, in some ways, these are just like the fundamentals of humanity. So I think in some respects you have to, there's sort of due diligence is part of it, but it's just ultimately at the end of the day, like going in like in a respectful human way, realizing that you're developing a relationship, which people will often say, it's like that's what's going to get the agreement is a strong relationship that leads to the deal. So, I mean, I think that's probably like what I most think is that knowing from the very start that it's a relationship you're beginning. So you're on your first date, you don't come running roaring guns blazing.
Can I just add one thing? Because Merle, you really touched on something. And I'll put it a bit more crass, but don't lie either. If you're trying to enter into a long-term relationship, and I would say this for any of the parties, but in particular industry, public governments do it all the time, so they almost don't count. I mean, if we were to say don't lie, we would not have many policy initiatives in the country right now. I'm quite jaded when it comes to that, and I would comment on all political parties. I'm nonpartisan. They're all the same in this particular area. None of them can actually tell the truth when it comes to policy development, but let's put that aside. When you're acting for industry, I really remind it's really tough sometimes to tell the truth or to not lie. There's maybe a slight difference between the two, but don't say things you don't mean. And it's a human thing. Just picking up, Merle, what you said about human and about how you treat your family and how it's tough. You may be in a really heated negotiation, Robin. I know you've been in many of them. And the inclination is I'll just say something, make somebody feel good across the table. But if you're trying to develop a long-term relationship and you start losing credibility, if you start getting called out, it can take, I think, Merle, you had mentioned the word patience. You've got to have a lot of patience, because I've got more work from that alone, where companies will go in and say A and then not deliver on it. it just generates work. It's nothing but a work generator for lawyers. Because what happens is you lose credibility at the table. You have to start all over again. I've got numerous, actually, what a few of the files that I am personally involved with, most of them are that there's a breakdown of trust. And so the one thing I never, ever do is lie, ever. And by lie, that sounds a bit crass. Of course, I'm a lawyer, and I shouldn't, but I mean in terms of I never deliver, and I won't deliver them for clients. I will never deliver a mistruth at the table, never. I was chief treaty negotiator for 3.5 years, and I lied every single day of that job. I speak very publicly about that. I'd get asked by a chief about whether we have a mandate. Oh, no, we don't have it. Of course we had a mandate. Of course there were numbers. Of course there were. And so it's not really helpful to build trust. Sorry, I didn't mean to, I probably hogged some time there, but I think, Merle, your point about the human element of this, we get so focused on that tech, and really, Robin, you were saying the same thing. It's that human component that I think from an experiential perspective is probably the most important.
Yeah. So kind of fast forwarding kind of to considerations about the end of the project, or if something goes wrong that the project needs to be abandoned, or even kind of the ongoing relationship once the project comes to development, let's say a mine, for example. So how can nations get security that industry will take care of the project site even once production has ceased? What's Tech's approach to this, Robin? I mean, obviously Tech doesn't have any, I don't know, anything could happen, I guess, but it's like, if the worst happens and the company, can't, what happens to the mine? And it for centuries it could affect the land.
Yeah, it's a great question, and I think it's a question that we get asked very frequently by Indigenous groups, who I think, for obvious reasons, are most they're the party who typically is most concerned about legacy around environmental cultural effects. We are frequently told and reminded in meetings, as well on Friday, that one day we will leave and the Indigenous community will still be there. And what are we leaving them with? And that is an absolutely fair question to be asked, and one that needs to be answered in an encouraging way and in a credible way. Otherwise, you will lose trust. I think that it's a part of the history of mining that I think the industry really does struggle with, like the whole industry, because the legacy of mining in a lot of instances is not very good. It used to be, the joke used to be that the only thing you used to do to close a mine was shut the gate. And that's not wrong. So I spent some time as the manager of our legacy portfolio. So if you've been mining for 100 years, you're going to have some legacy sites. So we managed that group of people. There's 25 of us. So we managed about 30 sites in North America, a couple in Latin America, and one in Australia that had been mined previously. Most of them were, by today's standards, much smaller. A lot of them were mined, like the oldest one had been mined over 100 years ago. So in those instances, those mines were shut, and they were shut like on the weekend. Like just, it was like, somebody walking around town and said, don't bother coming to work on Monday because the mine's shut. But there was an expectation it would reopen when metals prices rebounded, which just never occurred. So that group, we were going back and cleaning them up is what we were doing. But Tech is a long-lived company, so we've got the financial wherewithal to do that. All of those mine sites predated what you have now, which is sort of modern closure and bonding policies. So we put bonding in place now. Governments hold that, and to use that. So if you run out of cash and you close and you're bankrupt, the bonding should step in and the government should clean up the site. But I think if you're trying to work these things out with Indigenous groups, I'd say they will typically tell you, one, they do not have a lot of confidence in other public governments to make good. So they don't trust the province to clean up. And I mean, I know the folks from the province of BC who try and do this, and they're nice people, so it's not like they're not interested in doing it. But I think that's a fair concern to have because they don't have a long history of doing it either. And so what you'll see, I think, increasingly is Indigenous governments, and I think, Merle, your point about, then the next really interesting thing will be to see how the Indigenous legal orders are then incorporated in things. So something that's going to be interesting is like, well, who's going to access the bonding and do the work? I think you give it 5 years and it's not going to be the province. I think if you have a site that goes under, it'll be the Indigenous government that takes over the site and closes it using the financial resources they have. I suspect the province will be, BC and other provinces will probably be asked to step in more on abandoned sites. So when the bonding runs out, that's not going to be an excuse. Indigenous governments are going to expect the work to get done all the same. But increasingly, I think what you see as a mining company is you're expecting to make commitments. You're expecting to have contractually enforceable obligations to the Indigenous group. They can hold you to account. They can compel you to do the work. They can come on site. They can do inspections. They're going to do the reclamation work either as contractors or alongside you. You're going to do closure planning together. So you don't just present a plan, they write the plan, you do it together, which we've got some experience in. So those are the sorts of things that I'm seeing. But it is interesting. And Tom, I'd be interested at Merle as well. But what we often say is like, if you're going to pitch a new mine, you're actually pitching the closure. Like that's what if you want to open, you've got to explain closure. Because nobody wants you to open unless they're pretty confident that you can close it in a good way. And so closure also means not just, we often use the phrasing, it needs to be geotechnically and geochemically stable, which is a compelling PowerPoint presentation if there ever was one, which basically means the thing doesn't fall over and it doesn't leak, right? But increasingly, that's not going to cut it. So people are going to want to say, like, what kind of social legacy is this thing leaving? How is my community better off for you having been here? And I think what we're finding is that internally, that's also what our employees want. So you're a big enough company, you have to be in a place that people want to work. And I think most people actually don't want to work for mining companies if they think what they're there to do. I don't think anybody wants to be involved in that. So I think it's, we're not, I think the most important people in that conversation, but I do think that trend of closure legacy and how are you going to secure that future is increasingly the most important question.
Yeah, I think that was a very complete answer from my perspective. Only addition I would make is really non-Indigenous, just playing as already said, Robin, was I would say in sort of more recent agreements that we've been involved with, acting for companies, the Indigenous governments are very much focused on adding in additional measures by contract into the agreement. So over and above the regulatory requirements that Robin had mentioned, but contractual understandings that will stick with the project going forward upon closure. And so we're seeing more and more sort of sophisticated demands, more and more sophisticated requirements to get, in particular, First Nations on board with projects. And so you see the market reacting to that, and you see again more sophisticated agreements as a result of that, and understandings and commitments on closure. That's really all. I think that was a really complete answer that you gave.
Yeah, I mean, I think the issue of security is it's not an often. I mean, I think it's common to negotiate security above the current regulatory standards, which are pretty low in British Columbia. I don't know how they are across the country. For like the security that needs to be in place for really operating mines, but I mean, really any resource area. Like I think it's just like it's a risk factor. I think like the more volatile or potentially adversely affecting whatever the project is, like say diluted bitumen, like I think then you get, like obviously something like Trans Mountain, like there was a really hot, and I think that was like a spill was the most actively thought about like aspect of the project. And that was also like that sort of the fear factor around that led to lots of opposition, and also like became part of like, what Trans Mountain sort of brought as sort of like as a package of, but I think it's very common though to try and negotiate above like what the existing regulatory standards are. you put it into like the current context of like where nations are having a much greater say about what the regulatory standards are, I think that, I mean, you could certainly see like a shift to nations being much more involved. Like it would actually, there's actually a complete logic. Like I think that it makes sense that nations would at least be the really big determine. They would determine whether or not something is restored, like to the appropriate standard. I do think that you'll probably see much greater focus in environmental regulatory reform by nations sort of trying to increase the potential role of security. I also think that there is like much greater thought, greater sophistication sort of coming to like focusing on the way projects are financed, which has nations like our First Nations or Indigenous peoples like putting pressure on lenders also. I think over time, I think you're probably going to see a much greater like focus on the security that's in place to close any project, whatever that looks like. But right now, I think there's also an answer like that nobody really knows. Like, you know, like right now, I think it's probably fair to say it's almost insufficient across the board. Like there's probably more, like most nations experience probably is that like the security and the cleanup almost always fails, and there ends up being some degree of like of Crown involvement in the cleanup, or their relationship with projects is that things don't ever get cleaned up to the degree of restoration. Like that's probably the Canadian experience. So I mean, I think it's definitely an area that has a need for greater improvement, and I think it's going to be in all of those areas. But over time, I think that the security and the uncertainty around that will drive to a much better understanding of like what is appropriate security for any given project. So I think it will trend better for like not just First Nations or Indigenous people, but for all British Columbians or all Canadians, because at the end of the day, cleaner sites. It's in everyone's best interest that like that major projects like don't pollute or are abandoned. So sorry, Siri wanted to jump in there.
Yeah. Yeah, thanks for those realistic answers, and yeah, that's interesting, especially Robin, that you know opening is considering about closing. That's a really great way to put it. So we're gonna open it up to student questions soon. But I have a few more questions, and Robin, can you speak to the Glencore deal at all? I don't know if your practice kind of ran against it at all, but obviously last year at Tech was really wild, and it was so just this Glencore deal. So Glencore is a big Swiss mining company. Tech is selling off their steelmaking coal business to Glencore for like $7 billion, $9 billion. And okay, so when Glencore made this, said part of the deal is to honor the existing agreements with Indigenous nations and to work with local Indigenous nations to identify opportunities to increase participation in benefits from the activities from the business. So it kind of sounds like your practice might have really kind of run into this deal in amazing ways. Can you speak to that at all? I don't know. It's not closed.
No, but I think I'm public enough. I can probably say it without getting myself in trouble. So that's right. It's not closed. So for folks who don't follow the tech news, which I mean, what else are you doing with your time? Yeah, it's about a $9 billion transaction. So these we've got steelmaking coal operations southeast BC. Glencore, very very large company, right? They do. They're a really interesting company actually. They do like oil trading, commodities trading, they're kind of in everything. So because they're a foreign purchaser, right? So this is all subject to kind of like approvals, commercial approvals. There's also a couple of Asian-based steel companies that are buying, right? So we're like a way for them to basically hedge against high metallurgical coal prices because they use that for steel input, right? So it's different than thermal coal, right? right? So not for power, for steel. So a transaction of this size basically touches on every part of the business. So if you're going to split up a business like this or bring in a business like this, it's like every single aspect of your business will be involved in the transaction. So the hardest part is actually to staff up the deal without giving away the deal in advance, because you have really severe market risks if you get disclosure in advance. So that was interesting. You get lots of fun project names. One day you too can work for a business where people dream up energetic things like Project Omega or whatever they call it. Nothing fun, sadly. So interestingly though, when people are doing the deal, there's just the like big commercial terms. How much are you paying us? When are you paying us? What am I getting? But to actually unpack and give effect to the transaction is an enormous amount of work. So one of the things that's central when you're doing a line deal these days, and I'm sure Tom, you advise people on M&A work all the time, is actually one of the things that you're getting, so to speak, when you're doing a big transaction like this is what are the regulatory authorizations? What are the agreements with Indigenous groups? Because that's what everybody wants to know. Like can I only run these mines until the end of permanent mine life? If I wanted to extend the mine life, is there any more life? If there is, do people want you to build it? Do you have agreements in place that would help facilitate that? Like those are really core to people's understanding what they're getting nowadays. I think it's probably fair to say that 20 years ago, all you would have done in that space, you wouldn't have been worried about authorizations. You would a little bit, you want to know they're complying with the law, but that's it. And you'd want reports from geologists about proven and probable reserves, right? And nobody may be aware of this, but coming out of a former mining scandal, right? There's on the Toronto Stock Exchange, there was like really strict requirements around filing approved reports that say how much resource you have, how much reserves, and there's standards for drilling and all sorts of stuff. That's what people used to worry about. Now they know that you get all the reserves in the world. If you don't have support of Indigenous governments, yeah, you got nothing. So it's a really important part of the deal, right? Is figuring out, what is the lay of the land. So interestingly, when you announce these things, you try and distill a lot of that complexity into like one line. So then you have to work with the comms people and they want to know what they should say about Indigenous agreements. And so that's what I got intrigued on. I can tell you, because I don't think it's giving anything away. So the main Indigenous group in that area of the province is the Snaha. Very sophisticated, very clever. So they knew that, in fact, all of their agreements with us have to travel with them anyway. So it's not like the incoming party has to. They have to take out the agreements and give effect to them. So it's not like that was actually an open-ended question. But that gets very complicated for the public. So you end up sort of having these glossy statements to just try and communicate what the deal means generally. But since you guys study law, and for lots of people, if you think about this stuff deeply, you'd think like, well, that's got to be weird, right? Like, how can you enter into a negotiated agreement with an Indigenous group and just sell your assets? I mean, I don't know how your deals look, Tom. Our deals don't look like that. When we sign deals, if we sell assets, you have to assign the agreements. The agreements go with them. The incoming party has to promise to take them up, and they have to implement them. But then I think it's also a reflection that we have ongoing dialogue going with Indigenous groups, and that's actually a perpetual part of our work with them. We're always talking about, are our deals giving effect the way that you want them to? Are we delivering the benefits that you expect? How is the community doing in relation to how we're doing? So that's all. So that statement's kind of intended to reflect that effort that we've been making currently to communicate a desire to take up and build on it.
Yeah, very interesting. And so now a question, kind of a specific kind of news, you could say, question for Tom and Merle is just about this Trans Mountain expansion pipeline. Obviously, it's been in the news for years and years. And recently this year, they announced another kind of overrun on the budget of the expansion project. So my question is kind of just generally, what went wrong with the expansion, with the project, with the pipeline project? And what can we learn from this in the future? And I mean, such a major project, so obviously tons or maybe not a lot to say about it, but just for a quick summary about the pipeline. So the federal government bought it from Kinder Morgan in 2018. They bought the entire pipeline in 2018 for more than $4 billion. The cost of the expansion was estimated around this time to be $7.4 billion. And the actual cost as of this year was nearly 34 billion, so 5 times the estimate.
Is that all legal fees, Tom?
And yeah, I mean, so yeah, what went wrong here? And I mean, are those numbers insane for Edmonton to Burnaby pipeline? Like, is 34 billion insane? I can't tell. But I mean, 5 times the estimate is crazy. But yeah, so what went wrong and what can we learn from it? Tom.
Well, we have a limited amount of time, so I'll try to be brief, but this is really, it's very, there's a lot of moving parts on this. I know the project very well, but in terms of the cost overruns specifically, I don't have any sort of insight into other than what was said publicly. And there's a litany of different items, including regulatory approvals. I think they listed their agreements with Indigenous peoples or engagement with Indigenous peoples as one of the reasons. So the project gets consulted on, federal government decides they're going to do some more consultation. Some of us will know this decision. They do an awful job consulting. So this was all under reconciliation, right? We're going to do the right thing. So what they do is, as the court referred to them, they send out note takers. This is after it's gone through, in my view, what is a platinum grade regulatory process. And I am of the view that it's probably one of the best consulted on projects in Canada in terms of the evidence. So Canada says, of course, well, we're going to do even better than that. We're going to go and consult again. Of course, they go out, and what the court refers to as the note takers going out, but no authority to change anything. They sat there and listened, and had no ability to make any changes to design, to output, to anything. And of course, the court quite appropriately said that's not adequate conduct. Once you, as the government or as the Crown, say you're going to do something, the honor of the Crown kicks in, you've got to do it. So that's, I mean, this is actually that, as important as that is, and I think we could talk the rest of the day on that one point. I do think this is part of a much bigger issue. And really the blame is solely focused on public governments. Again, I'm nonpartisan. I don't think any blame rests with, any material blame rests with Indigenous peoples. I don't think any material blame rests with industry. I think it all rests with public government and the lack of a long-term, Robin and Merle may have heard me give this speech before, but I've been giving the speech for 20 years and stand by it. The lack of a long-term sustainable public policy approach to these issues in Canada, which we do not have. And there's no hope of having it, I think, in the foreseeable future. There's no, including in British Columbia, long-term sustainable. And what that means is it's also folks being treated equitably. So this is a consequence, I think, of that sort of a haphazard approach. Well, we'll buy it, that'll solve the problem. Because this was a perception that there was a problem. And of course, government buys the project. And it's a really sad story overall. I mean, the project's a great project. It's necessary for the economy and the country. It benefits the entire country in terms of the tax dollars that it raises to our education, health, and highway systems and everything else. I will just make one other comment, and it's really my comment about the long-term sustaining public policy approach. I'll just make a comment about British Columbia. I usually try to do this every time I can publicly. And again, this comment is directed towards public governments, not First Nations. So we're here talking about resource development. It's great if you're a First Nation and you've got a mine in your backyard and you want it in your backyard. By the way, it's not great if you don't want it. But if you want it in your backyard, you work out an agreement and you get revenue sharing with the province. The challenge is that we've got 200 First Nations, give or take, in British Columbia. And so when you look at all the different public policy suggestions coming out, the evidence historically is that a relatively small proportion of First Nations, and I'll focus on First Nations, receive any of the benefits, whether it's having a mine. And again, it's quite appropriate to be dealing with the adverse effects of the road, but where's the grand plan? So I'm not going to name the other First Nations. There's a few very close to the Lower Mainland that don't have safe drinking water, that don't have working sewage systems, drive their kids to school on logging roads, and they don't get the Premier Special Phone Number, Liberal or NDP. They don't get the federal ministers. I've spoken to federal ministers in the past going, there's no game plan for those folks. And there isn't, and there won't be for the foreseeable future, because we don't have a plan on how to deal with the massive challenge we have as a province, Indigenous and non-Indigenous, about how we're going to all live together. And so finally, the other comment I would make, and it picks up on the Glencore deal, is and I mentioned this to Robin, but we have a serious flight of capital leaving. And again, the blame here is not on the, I don't want anyone to read, it's not the Indigenous issue or Aboriginal law, Indigenous law, we can deal with, and we can create a very dynamic economy. I'm absolutely convinced of that. But understand there is a serious flight of capital from Canada, and in particular, British Columbia forestry. We can all have an arm wrestle whether it's dead or dying. I think some would say it's dead. It's actually dead now. It's not First Nations' fault. Just to be very clear. Is it public government's fault? Absolutely. Mining, generally, again, it's no reflection on tech, just generally, the amount of capital coming into the country is just, now, fortunately, we are one of the resource-rich jurisdictions on the planet, but we've got a whole bunch of other competitors out there. But what is it? The latest that we're short 1 million people in this province are short a doctor, and there's no game. Our education, so we're going to what the largest effort, again, I'm nonpartisan, but you look at all the competing pressures and you realize there's a whole bunch of First Nations that won't be able to avail themselves. They don't get the deputy ministers hopping on a chartered plane to go visit them, and that's the majority of them. So we need a real reflection point. This isn't about acknowledging territory, and these things are all important. It's about really affecting people's lives, and we don't have a long-term game plan. So it's lurching from one policy approach to the next. I've been highly critical of provincial government, both Liberals and NDP, for the past 20 years. It's really becoming palpable. And so I don't know what the long term is for our province, but certainly First Nations people shouldn't wear it. But we need a longer sustainable plan. So sorry, that was a little bit more, but to me, these things are they're all linked. So over to you, Mark.
Yeah, I almost had to laugh really a little bit at the question, because it's like it's like nothing went right with the TMX, like, so that's part of it. The other part of it really is just, I mean, once it became a publicly owned project, it was the public purse, and that purse is infinite, apparently. Like, I used to actually, when the project like first, because I sort of like talk about life of project, life of zombie project, like really for for my career, I feel like it still going on. Is because I was like, saw it like die and then get brought back to life, and like now it trudges on, more expensive than ever. I think if the budget would have been designed with the worst case scenario of opposition and all these things, then maybe the budget would have been closer to it. Because actually, when I used to like just guess, I used to like literally just make up numbers, like when I'd say things about it, especially in social media, I'm sure before familiar with that. I would like just make up numbers. I'm like 30 billion. This is going to cost $30 billion to Canadians. And I just literally made it up. But I partially made it up based on like things like every single hydro project that's gone like extremely overrun when a major project is built in Canada. They're always extremely over budget, but nobody could have ever imagined like the twists and turns. In fact, some of these at Cambridge is doing their doctorate on the Trans Mountain as a case study. I mean, it is like a case study like no other, to try and like what could you possibly do wrong every single way. I think that it could have been, obviously it could have been done better, no doubt. I think anybody could see that. I think that like if you compared like what say Canada did with the Trans Mountain versus what British Columbia did with trying to deliver LNG projects, I think that was BC's like Liberal government actually mostly actually did a much better job at sort of like realizing that they had to be major players and that they had to potentially help deliver accommodation agreements themselves. Whereas the Fed sort of sat back, bought the project, and then also was sort of wearing every hat they possibly could, in this scenario. And of course, there's this complete Keystone Cop like approach to project delivery in the end. That, and of course, no one could have imagined the hyperinflation that we've experienced. So that's another really gigantic factor for the cost. But there's also just I don't know. If you're being really honest, there's complete stupidity to the way that the contracts were consistently let for the project. Like there really was no budget controls until it became just glaringly obvious the budgets were so overrun. It had to get to about 20 billion before anyone was really like, whoa, like maybe we should start putting some budgetary controls. Like I know lots of contractors like First Nations and other and main contractors where there was just like normal rates and Trans Mountain rates. And the Trans Mountain rates like had a 40-50% like higher inflationary factor to it. And the contracts were signed over and over and over. So of course everything's gonna get like it's just gonna go like out of control. But I think the public purse is probably like at some point it did not become it did not become a bankable it sort of failed to be a bankable project when Kinder Morgan abandoned it, I think. And then it was just driven by the public, by the larger sort of public policy reasons that I think Tom was highlighting about, it being in the national interest and it being like in the long term a really significant financial contributor to the Canadian economy. Like those things start influencing it, which isn't really what the proponent should be thinking, that's the strange multiple hat like factor. But ultimately it is a lot. I do agree with Tom that it's a lack of like sophisticated public policy thinking about how to deliver major projects and how to think through what are the complicated subjects of our practices of how to fulfill the duty to consult, what's an appropriate framework for accommodation, and spelling those out in clear and transparent ways. Like all of that wasn't really done. All of that's still not really done, but there's very few projects like that are like the Trans Mountain where it affects like maybe 70, 80 Indigenous groups. So you just have this multiplier of complexity. And it wasn't just, obviously it wasn't just the Indigenous factor that like accelerated cost. It was all these other things, too. Like there'd be like a long list of reasons why it went over budget. Part of it though is just a public government trying to deliver a major project is just, I've probably never, show me a history where they've delivered a project on something on budget. But anyway, I think it's probably my best guess, but I'm amazed that the numbers actually went beyond what my greatest imagination could have been when it was 5.6. Like I think I tapped out at 30 billion, but who knew? 45 billion it is.
Right, well, we have time maybe for one or two student questions. I'm not sure if anyone has anything pressing. But it's kind of a tall ask because the prof from the next class literally just walked in the door and then walked out. So, but yeah, I'll call it there. Thank you again so much for Robin, Tom, and Merle for joining us here today at the law school. And yeah, really great, informative talk and inspiring talk. So thank you again, and join you for a round of applause. Thanks so much.